інтерв'ю ми чекаємо на вас.
Все?
У нас 40 секунд. Добрий день.
Good afternoon. Thank you for joining us. My name is Olga Atamanova, and it's my pleasure to see all of you join us in Ukraine Media Center current form. Is the 614 of the full-scale invasion of our homeland by a Russian aggressor. It's been 10 years of the war, and I want to thank the representatives of all the mass media who tell the world the truth about our heroic resistance. Today we have invited you to a presentation of a very interesting report. We will talk about the analytic report by human rights activists about the punishment for collaborationists. We know there is a demand in the society to have all of the collaborationists punished, to make sure that the justice is established in this area. We understand that our law enforcement agencies are in need of such tools they can use to bring the perpetrators to liability. But there is yet another side. We know that the Russians use this area as a scaremonger to intimidate our population that is forced to end up in the temporarily occupied territories. They tell our people that they will all be punished, that they will all be brought to some kind of liability. So let's talk about what works, what doesn't work. I'd like to introduce our speakers today. It's Aliona Luniova, Advocacy Manager at ZMINA Human Rights Center, Onysiia Syniuk, Legal Analyst at ZMINA, and Andrii Chernousov, Leading Expert at Kharkiv Institute for Social Studies. So, Ms. Aliona, let's start with you. What have you been able to research? Good afternoon, dear colleagues. I appreciate the interest to our report. Well, I would like to start with the fact that the legislation on collaboration emerged in Ukrainian criminal code. Those articles appeared that describe the cooperation with the occupiers, assistance to the occupiers, and collaborationism. In the criminal law, currently, there's a lot of types of activities that fall under liability. Many types of activities that can be exercised in the temporarily occupied territories, and those types of activity are not described in a very precise detail. But to add more context, collaborationism is denial of armed aggression against Ukraine, collaborationism, different offices, appointment to different offices, propaganda of narratives of the occupiers in the education sector, different information activities, elections, law enforcement activities, and it's not a comprehensive list. And there is a very broad range of those problems described by this legislation. It results in lack of understanding by the people what exactly falls under criminal liability, and we think that there is such a position, that such an opinion that this legislation should mostly prevent cooperation with the occupiers before the territories are occupied, so that we send a very intense signal to those in the occupied territories that such activity will be prohibited by the criminal code of Ukraine. Unfortunately, some parts of our country are occupied for more than 9 years, and it creates certain sentiment in those territories because people don't really understand what Ukraine will bring them to liability for, and they are afraid that after the re-establishment of territorial integrity, after Ukraine regains control of those territories, that those people will end up in prison. And this is what Russian propaganda plays on. So getting back to the legislation, to specific articles, I would like to say that those draft laws did not undergo verification. There was no time in the parliament for the first and second hearing for civil discussion, so those draft laws were approved with certain problems as they were registered. But the expert department of the parliament, they expressed certain concerns and mentioned certain problems that would emerge during application of the articles, meaning not very clear description of the details of the crime. So it was kind of predictable. And for the time being, there are at least 12 draft laws registered in the parliament which suggest amendments to the Article 11.1, which establishes liability for collaborationism, or Part 2, or Article 111, Part 2, which describes the assistance, the liability for the assistance to the occupiers. And unfortunately, those draft laws are mostly such that don't take into account the practice of application of those articles. They don't take into account the problems that the law enforcement officers are facing during application of the articles. And the last draft law that was registered on the 9th of October this year, it suggests the intensification of liability for the crime committed. And to finish my speech, I would like to say that we hope that the Parliament will have a balanced discussion regarding the amendments to the Articles 111 paragraph 1 or 111 paragraph 2, because it's very controversial in its application. It does require amendments. That's a joint opinion of civil organizations and law enforcement and international organizations. What should be taken into account is not only the practice of application, but also the prospects of reintegration, which does not increase the liability, but also the measures that the government may take to prevent the crimes, such as cooperation with the occupational regime. Onysiia, we understand that from the point of view of legislating, not everything is okay in terms of bringing the collaborationists to liability. So what are the risks that can emerge in these processes? Unfortunately, these problems already arise. We can see it even in the interviews with the representatives of the law enforcement, as they are forced to use this imperfect legislation. So there is a demand for establishing the law, for bringing the perpetrators to liability, but imperfect law is what creates obstacles for bringing such perpetrators for liability. And talking about the problems that we were able to identify, first of all, is unclear wording. In those articles, both about collaborationism and assistance to the aggressor state, there are wordings that allow those who apply them to construe them in a different manner, which creates very different practice. For example, such wording as material resources, when the material resources are handed over to the aggressor state, or interaction with aggressor state. For example, in the interviews, the representatives of the law enforcement agencies, they mentioned that when they come across those notions, they don't understand what exactly falls on under this or that term. In practice, it reflects in the following way. When we talk about material resources during the court proceedings, it can be handing over of the food products to the representatives of aggressor state, and any economic activity or labor activity in the occupied territories, and even being paid a salary. For example, there were two cases that we were investigating. In one case, it's an electrician who took an office in the administration, in the occupational administration, and in another case, it was a man who agreed to serve as to work as a security guard at the market in exchange for, or at the pharmacy to be paid with food products. And talking about law enforcement, does for example paying of taxes constitutes such handover of material resources? And when we talk about lack of clarity, it's not only about unclear wordings, but it's also about the correlation of of all those articles. They are not only those new articles about collaborationism and assistance, but also the articles that existed in our criminal code before, both regarding the high treason and justification of the aggression. And when we try to draw the division line between those articles, we talk, for example, about propaganda in the educational institutions. The article on collaborationism has a part which contemplates liability for such activities, but looking at practice, we know that sometimes propaganda in educational institutions is not different from other cases of propaganda in educational institutions, and they are being classified as assistance to the occupational regime. And the same thing with material resources. The article, for example, on collaborationism describes this just as well as in the paragraph about assistance to the occupational regime. And the law enforcement officers, they mentioned that a division between those cases is very vague to them. And we also have to look at the side of the punishment, because when we talk about those articles which are difficult to discern, when we talk about the public propaganda, it's a misdemeanor. And in other paragraph, it's about the prohibition to take any offices. And when we talk about the article about justification of aggression, then it's the restriction of freedom. It results in the restriction of freedom. So it's a legal indefinition and uncertainty for those people who end up in the occupied territories, and they don't know what are the limits of their allowed activities in the occupied territories. And when we talk about other problems that emerge, it's about prioritization. What we see for the time being is that our law enforcement system is overloaded. We can see it in the number of the cases being investigated by our law enforcement. It's all about the general crime, but it's a huge workload in part of the war crimes, and we understand how difficult are them. And it's more than 1,000 cases of collaborationism, so it's difficult to cover all this massive without certain prioritization. But if we check out the practice, we understand that the majority of those cases heard about the cooperation with the aggressor state. Those are the cases about the public origin, it's like the people who liked or posted or shared something on the social networks such as Odnoklassniki or VKontakte to glorify the participants of the so-called special military operation. So for proper correlation, even the law enforcement officers mentioned it, that they should focus on those persons who took public offices that are of threat to national security and who are of threat to safety and security of people in occupied territories, or who voluntarily became a part of some military units. And also it's about the conviction that we can observe during all the stages of the case consideration. So there's a lot of aspects here. For the time being, all 691 convictions, among all those 691, there are only 2 cases of justification and or exoneration, which was due to the lack of evidences in the court, which brings us back to the fact when the law enforcement officers, they mentioned that they take minimal amount of investigation before the case is brought to court, because due to the work overload, they cannot pay proper attention to every single case. Also, a lot of convictions are related to the fact that a lot of cases are being considered in absentia, and there are agreements signed about the absence of the perpetrator. So there is no alternative practice here. There are no appeals to those cases, which means the system is imperfect. And a very bright example is this case of the electrician from Le Mans. He was convicted by the court, and with a restriction of freedom for 3 years, he was deprived of the right to take public offices and deprived of the right to take part in servicing of the electric systems. But when his case got to the Court of Appeals, Court of Appeal came up with a different award, and he was only restricted in his right to take public offices, and he's got a conditional sentence. First of all, the nature of guilt recognition was not taken into account. After all, this person would be deprived, if that person would be deprived of his right to exercise his professional duties and skills, he would be deprived of any means to maintain his life, maintain his family. So the Court of Appeal had a better opportunity to take into account all the details, and thus came up with the different award. So in many aspects we can track those problems. It's present in the court cases and during the investigation as well, because we see these problems spreading over both judicial branch and the investigators, because again, people do not understand where are the limits of criminal liability and their survival in the temporarily occupied territories. Well, in continuation of that, one of the most widespread cases is acquisition of Russian passports. Russians use this instrument all over the place in the temporarily occupied territories. They impose their passports. They make people obliged to acquire Russian passports to be able to be served in medical institutions, to send children to schools. So does it entail criminal liability? We've heard many statements by different government agencies. One of them says, for example, don't take the passport. Another says, yes, take the passport to survive. I think that consensus is not to acquire Russian passports, because it's a documentary connection to the aggressor state, not in the terms of further liability, but more in terms of personal safety and security, restriction of ability to leave, or the mobilization to the armed forces. But in terms of collaboration activity, for the time being, according to the legislation in force, in no case acquisition of a Russian passport is something that constitutes a collaborationist activity, and I hope it will remain like this, because first of all, acquisition of Russian passport cannot be something punishable on a criminal level, even if we talk about aggressor state. But if that person takes a public office, they will be liable for taking such an office, because you cannot take an office in Russian administration without Russian passport. So this will entail liability, but acquisition of the passport itself will not, specifically given the fact that there isn't the atmosphere of oppression in the occupied territories. People cannot get whether medical or educational services without such passport. So this is the situation. Thank you very much, Mr. Andrii. We know that you were able to discuss it with those who were applying those legal norms. So what is their opinion? Well, you know, the topic of torturing in the police seems even easier than collaborationist activity, and all our attempts to find the respondents, they were very difficult. You know, it's like a children's game, like a rotten potato. It's there, but nobody wants to take it, and nobody wants to talk about it, right? So I think that our law enforcement system sees it as a challenge as well. You know, don't think that it's a dedication to investigate cases like that, because there are lawyers working there and they understand it clearly that something is not right there. This uncertainty principle, or the principle opposite, the principle of certainty, which should be fundamental, it does not exist there. People don't know how to construe those articles. People work in the criminal justice system for a long time, and it creates certain imprint on their activities. Like Onysiia said, the lack of evidence, for example, it results from the fact that there is no practical possibility to exercise all the investigative actions and activities, and it means that the quality of investigation falls, and behind every investigation there are specific names, there are specific investigators, specific prosecutors who drive this case all along the procedure, and they have impression that things don't happen correctly in this process. So I would like to mention that this study is of a significant not only in the sphere of crime analysis, but it's also about the future of reintegration. For us as a Ukrainian state, as a legal Ukrainian state, it's a repetition, it's a rehearsal before we liberate the occupied territories, which were occupied for more than 9 years. If we don't pass this test now, it will be very difficult for us later on, when the territories will be liberated which were occupied earlier. The population there is larger, and the situation will be more difficult there. It doesn't necessarily mean that we are supposed to liberate them right now, but we should send a message with the list of activities so that people can build their own strategies. I understand that many people collaborate on a conscious basis, but it's specifically them on whom our investigations should be focused on, to establish the facts and to reestablish the justice. It's important for the state, it's important for the people who were living there, because some people were diligent, some people were trying to abstain, but some decided to collaborate right away. And it's an important moment of justice that should be established. Ukrainian state should establish it. And on the other hand, we also don't want those awards to be disputed because, as Onysiia says, a lot of cases are heard in absentia. For a quick reference, I can say that in many countries the procedure in absentia is not even used because thus the principles of representativeness and exercising of right to protection are not exercised, and as a result of that, people then may go to, for example, European Court for Human Rights, uh, disputing it as a violation of a basic human rights, as a basic principles of protection. So for us as a law enforcement agencies, it's not so easy to exercise this pressure because there is a pressure, and this report tells us about this, that they feel the moral pressure of the society to bring the most collaborationist possible to liability. And it's a trap because if you follow this pressure, you risk committing those mistakes that should not be committed by the justice system in a country waging a war. Well, you know, to me as a communications person, it's interesting to see a list of things that we should communicate to the people in the temporarily occupied territories so they understand better that this is a violation and entails a criminal liability, and this thing is not a violation. So what should we do? Ms. Aliona, you've mentioned that there are 12 draft laws to amend current legislation. So among them, are there those that are capable of solving current problems? Well, I think that not, because it's only criminal liability that should be a proper response to collaboration with the occupational regime. And now the legislator only covers this huge demand with the criminal liability, this demand for justice. And now we understand that criminal liability is not the only thing. We should think about lustration mechanism. Almost 10 years ago, we've survived those lustration procedures, and they didn't look quite like we would want them to look like. And we should say that the response of the state should be restriction of those people in their ability to take offices, to take public offices in future, because we understand that criminal liability for collaborationism doesn't describe any consequences. For example, we have to talk about what people were doing in those public offices, because certain government agencies, they just ceased to exist, and those who remained in occupation, they were basically taking offices to help the people who remained in occupation. So we're supposed to find out what those people were actually doing in those offices. On top of that, we should also say that there should be something beyond those court proceedings, because we have this legislation now, and it's important to say that currently the initiative is on the side of the deputies who have offices in the Parliamentary Committee on Law Enforcement Activities and protection of human rights. On top of that, the legislation doesn't take into account this long-term occupation, because those people living in long-term occupation were acting based on other premises. We have to take into account this situation in occupation, because, for example, if we bring to liability the teachers who teach under Russian program, Russian curriculum, for example, in Crimea is 30,000 plus teachers. So do we really want to bring 30,000 plus teachers to liability? Well, basically, right, we have to review the existing legislation, probably to review the code of administrative violations, or maybe we should focus on some crimes that entail certain consequences for the security of Ukrainian state, or maybe in lighter cases we should assign some administrative liability to them. So it's a key thing. There is a high demand from the Ukrainians, but they definitely don't want some woman reposting something in Odnoklassniki to be brought to liability, and people who were really collaborating, who were not expecting for the Ukrainian armed forces to arrive, they just get away with those crimes. So yes, we have to amend the legislation to add those changes. Thank you very much, dear colleagues. Do we have any questions on the floor? Yana Lomachenko, Ukrinform, can you please tell us what is the number of law enforcement officers and representatives of Security Service of Ukraine that you were able to interview? Well, we were guaranteeing the anonymity for our people, for our respondents. Well, so the total number of them was 20 persons. This number includes the representatives of the law enforcement agencies of Ukraine and civil barristers.
Listeners can understand how this the measures for collaboration will look, because you bring up a very good point that disinformation campaigns will exploit that as a way of encouraging Ukrainians in occupation to do something for survival, etc. And so for the outside world, they would want to know that it was fairly arbitrated. So that's very good. Number two, in the case of Alexei Kovalev, who was in Holopristan, who overtly worked to undermine Alexander Babich, the mayor. Do you have some cases that are so easy to demonstrate for people to say, this is an easy case we deal with, here are complicated cases where we have a lot of nuances? Дякую.
Давайте з методології. Що ми робимо?
Well, talking about methodology, we got familiarized with all of the convictions, with all the awards. It's 691 award as of the end of September. And we were not picking some specific case. The only specific case that we were picking, that we were tracking, was this electrician from Liman. And on his example, we may demonstrate that the judicial system may take into account their mistakes, but we have to ensure the full cycle of proceedings, of court proceedings. If Ukrainian citizens are forced to sign an agreement on accepting their guilt, it means that the people will never go to Court of Appeals with those cases. But if they are restricted in their ability to take public offices, people don't really care about this. But if the legislation changes and there will be penalties involved, it will change the practice very significantly. So we were not discerning any specific cases, but when we were asked from the occupied territories, more and more people started asking us, how am I going to be punished? Like, I'm a businessman, I'm a private entrepreneur, I was working as a team lead in a factory, or I was working in a school, for example, and we don't have the right answer, the exact answer for them, because when we read the Register of Court Awards, the answers may be very, very different. The liability may be very different, and we even cannot say whether the people will be brought to liability or not. So it's difficult for me to tell you about the cases that you've mentioned. And talking about the communication, about what's wrong is that the law enforcement offices, due to the legislation, they don't really investigate what people were doing in occupation. And when we were sending this signal, don't cooperate, it will result in liability. Well, we know that there were the teams in the schools who were afraid of criminal liability, and they were not agreeing to cooperate in Luhansk region. But when the occupation takes place more than a year, or in some cases more than 9 years, people have to decide on their lives right there, right now. And if as a state we cannot give them the exact answer about this liability, that we cannot promise that those people will be liable and those people will not be liable. And now the state has to take this responsibility, and they should say, okay, we will punish the people who exercise these activities ABC, but in the way that it looks like now, it cannot exist like now. People in occupation, they either wait for the Ukrainian armed forces to come, or they expect the Ukrainian state to come and punish them. And from the political point of view, we have to change the approaches, and we have to keep the balance between the security and understanding of the aspirations of the Ukrainians who live in the territory under Ukrainian control, and the loyalty of local population. We want to come back to those territories and to live in peace, and we have to amend the legislation in that way. Thank you. We have more questions on the floor.
I'm also a criminologist and criminal justice and forensic major. I lived in Donetsk for a long time, so I know a lot of people there. And the Armia Donbassa Partizani have asked me 2 questions and 2 specific examples pertaining to draft law part 4 of the CCU. For example, in 2016, a person in Kyiv, they make honey, and the enemy buy this honey. And this honey itself was used at one point to poison and kill 25 enemy soldiers at a restaurant in Donetsk. And that person has asked here today, asked through to me, will they be subject to that law of having transferred material resources, even though those material resources were used to kill the enemy? And another case is some guys who work as mechanics, and they fix vehicles in Donetsk and Luhansk, etc. And they sabotage these vehicles, and often they kill enemy soldiers, or the engine of the truck that's transporting enemy soldiers to the front line blows up, and then the vehicle is then destroyed. Are they then subject to having provided assistance to the enemy, even though they're using things like that to destroy the enemy? So their questions, they've told me not long ago, a couple of weeks ago, they want to know, will they be subject to this collaborationism law or not? Because they are partizani, and they use whatever method they can to destroy the enemy.
Прошу. Дуже цікаве питання. Дякую.
Well, it's quite an interesting question. Well, first of all, the legislation, the liability cannot be reversed. So basically bringing to liability is only possible after the year 2015, but it's very good example of what I've said, not only the formal actions like the handover of material resources, but we have to take into account the conditions under which it was happening. So it's important to mention here that if we read criminal code only, I would say that formally there was a crime, because the resources were handed over, maybe even voluntarily, but the law enforcement would never do this. They have a lot of other tasks, and we see it in practice that they really pick the cases, maybe not in all of the cases, but it's a very interesting focus to see what misdemeanors are treated in which manner in different regions, because the majority of criminal cases are opened in the territories that were recently liberated, and it will be very interesting to observe this law enforcement practice in those regions. But I think that people who resist in the occupied territories in practice, they will not be brought to liability, because we know the cases when people in communities remained in the offices with the occupational government, but they were not brought to liability, but their actions did not result in any harm to the state of Ukraine. So the practice is very difficult, and it's subject to further investigation and study. But in some cases, we've seen that some people, with regard of which such restriction activities are exercised, they were saying that they're being investigated in those cases of war crimes as those people who suffered as defendants. So they were tortured by the occupational government. They were sitting in the cellars, but it doesn't contemplate any impunity for them. So if this practice develops, and if these people are being asked questions like why did they stay in occupation, why didn't they resist properly, that will also be a very wrong way. We don't have enough materials to come up with the conclusions that defendants in those cases become targets to be investigated whether they collaborated or not. But such cases, they require further study and investigation by the law enforcement. I think that in the previous question and in this question, there is certain correlation about the perception, of the straight and direct nature of those cases. It results in those agreements on impunity, and there is no competition between the law enforcement. We have to investigate what were the results of those activities. For example, material resources were handed over, but what was the intention of such handover? And to study this, the investigators and all of the law enforcement system should have enough resources. And here we're coming back to the matter of prioritization that would allow us to investigate those cases in detail to make sure that those who intended not to cooperate but otherwise to support the resistance movement, to make sure they are not brought to liability, and those who really intended to cause harm to the national security, so that they feel the effect of all of the criminal justice system on them. Thank you very much.
Segura from the Spanish newspaper El País. I just want to know approximately from your experience and analysis, could you tell us how many of these 691 sentences were not properly conducted or were not properly shown that the allegations against these people were flawless? I mean, how many of these sentences were not properly conducted from your point of view? Thank you.
Дякую за питання, але
Thank you for your question. We have to understand that our perception is only limited to the fact that we worked with the register, and that means that we were not able to track this every single case on a stage-by-stage basis, like when, under which circumstances a crime was committed by this or that person. Everything we see is a court award, so we cannot make some unambiguous conclusion whether it was not enough evidences provided by the justice system. In some cases, we see those problems with lack of ability to discern. For example, when there was a propaganda in educational institutions that is construed as a case of assistance rather than collaborationism. So to what extent is this an error of the investigator rather than the imperfection of the law itself? And talking about those cases of public urges, this is when we see this problem the most, because it's the broadest category of cases, more than 30 out of 691, and it's about those posts, likes, and sharing on the social networks. And when we say that some of those people were who were committing such crimes, they are sentenced to 5 years in prison, for example, then it raises a question: how proper was the investigation? Yeah, that they get sentenced as a result of other application of other article, the glorification of occupiers. So the law enforcement can construe those public urges as the glorification. For example, if they apply the Article 111, paragraph 1 is the restriction to take public offices, but if it's a glorification of occupiers, is the prison sentence. Well, we don't have access to those proceedings, but we know who does. It's the Office of Prosecutor General. If we cannot analyze it in detail, the interest of our international partners, like Andrii said, it's a pre-test today. It's our test of our reaction, of how we react to the cooperation with the occupational governments. And this is how we're going to work after the liberation of those territories that were occupied for 9+ years. So we should work with those tendencies. We should change this problem on a systemic basis. The Office of Prosecutors General is supposed to become a subject which corrects this law enforcement practice. Maybe we don't amend the legislation, but we improve the practice. And this is where this prioritization thing comes on the first plan. We can analyze the standards and the application of the standards, and through the, so to say, a guidance, instructions from the Prosecutor's General Office to those who apply those articles, like National Police of Ukraine, State Security Service. We can show them what to pay attention to, and they can correct a lot of things in this way. Thank you very much, and I would like to wrap it up with a logical question. Were you able to present this report to our parliamentaries and, for example, to the Office of Prosecutors General? We started with civil public presentation because those statements that we made there, we communicated it to the Office of Prosecutors General and other offices. I hope they will take it into account. But what's important to have the society to see those cases. I'm talking again about the electrician from Le Mans case. So a lot of work here is done by the journalists, you know. There's a lot of time, or not a lot of time, between this moment when a judge leaves the court premise and when he comes back with the word ready. The journalists will see this period, and the society will pay more attention to those cases. If we don't pay attention to those cases, it means that the state can do a lot of things that can be wrong, and we will have to solve those problems, then the consequences of those mistakes for years and years. And we can correct the ability of the state to influence that. Just a couple of words to add. So it's not only a problem of criminal nature, it's a broader problem. It's the problem of unity of Ukrainian society, it's the problem of post-war recovery, reintegration. And us, as a representatives of civil organizations, we emphasize that you know, now it's all on the shoulders of the law enforcement, National Police, Security Service of Ukraine, the Office of Prosecutors General. You guys deal with this. It's a wrong approach. We have to share the responsibility as a society. We have to implement some alternatives, because me, as a person who studies criminal justice for 20+ years, you know, prison will not improve anybody. If we put those 6,000 to prison, there is just not enough space for them. So it's no solution. There should be alternatives. Yes, some people were collaborating, they were signing documents, and they should be brought to liability. And but there should be other alternatives other than prison sentence. But we don't have those alternatives now, and we bring it to the criminal justice system, and we have this system suffocating. We have more than 110,000 war crime cases, and on the level of legislation, we urgently need to find this solution. If law enforcement cannot deal with all of the cases, the Office of Prosecutors General should guide this work. We provide them with arguments. We do this work partially for them already. Well, thank you very much for this comprehensive work, your study. I think that we shouldn't postpone this for a single second. It's very important for us to make our post-war country happen as a state, so there are no internal disputes that will influence our future further on. So thank you very much, dear friends, for the interest in this topic. And our team is working on our schedule for tomorrow, so stay tuned. And we want to thank our security and defense forces for opportunity to hold events like this. Glory to Ukraine.